A few years ago, I received a call from a family that had been referred to me by one of my existing clients. Their father had recently passed away, leaving behind a will that divided the estate equally among his 6 children. Unfortunately, life had already complicated that plan before he ever passed away because one of those 6 children had died several years earlier. Under the terms of the will, that deceased child's 1/6 share was now passing down to their own 3 children. What had started as a fairly ordinary estate with 6 beneficiaries had quietly become an estate involving 8 beneficiaries spread across multiple households and multiple generations. The family had already found a buyer for the house, and the executor believed they were almost finished with all of it. Then the real estate attorney handling the closing called with news that nobody wanted to hear. The buyer's mortgage company was insisting that every beneficiary with an interest in the property sign portions of the closing paperwork, despite the fact that the executor believed they had the authority under the will to handle the transaction themselves. Suddenly, it was no longer a matter of coordinating signatures from just the executor. It was now a matter of coordinating signatures from the 5 surviving children, the executor, and the grandchildren who inherited their deceased parents' share of the estate, including a 17-year-old minor whose interest required involvement of his now remarried mother acting as his guardian for purposes of the transaction. What had seemed like a simple real estate sale suddenly became an exercise in coordinating 8 beneficiaries, multiple households, different schedules, different states, multiple legal interests, all while trying to keep a buyer and a mortgage company happy enough to continue moving forward with the closing. The family had expected arguments over maybe the sale price or who got grandma's china cabinet. They never expected that simply figuring out who had to sign the paperwork would become one of the biggest obstacles in getting the house sold. Now, when someone passes on, the house often ends up being a huge part of that estate, and none of the children want or can afford to simply go ahead and say, yeah, we're taking that asset and we're going to end up being the ones responsible for it. So the biggest problem doesn't come from the process itself. It ends up being the mortgage company. And I have to explain this to my clients in a simple way. It's, look, you as the executor, as the estate, as the beneficiaries, here's this asset. Somebody wants to buy it. You want the buyer's money, but the buyer doesn't have the money. It's a mortgage company, so you want the mortgage company's money. You're going to have some hoops that you have to jump through that you may not want to, but the end result isn't, well, the legal process says this, and according to the statutes, you should be able to do. No, look, the mortgage company has the money. You want it. They get to dictate some of the hoops you get to jump through. And if you don't want that, your recourse is, okay, we'll find a different buyer and a different mortgage company. And that in itself becomes even more frustrating. So let's walk through some of the issues that need to be handled no matter what, and then talk about the process differently with an estate versus using a revocable living trust as the owner of the house for the sale. So here are some issues that need to be resolved no matter what. If there are any mortgages, liens, other encumbrances, look, they either have to be paid off or assumed by the beneficiary. That's going to happen no matter whether it's a will or a trust. And another big issue is, look, somebody is going to need to front the costs for maybe a new paint job, new carpeting, the roof needs some fixing, maybe some new appliances. Look, that's got to come from somewhere. And it is different whether it's happening in probate, especially in North Carolina, which we'll walk into, or a solid revocable living trust. Now, let me talk a little bit just here about the difference between a solid revocable living trust and, yeah, technically that's a trust. There are trusts out there, we call them thin trusts, and this is probably going to be a video all on its own. 10, maybe 15 pages. What that trust is actually doing is it's saying, well, yeah, we meet the requirements for a trust, and here's what we want. But all the gaps, we're going to let the law, which is subject to the change by the legislature, subject to judicial interpretation, subject to all this other stuff, we'll let that fill in the gaps. I once sat through a continuing legal education course. It was almost 3 hours, and it was like the 187 changes to trust law since 2000, whatever it was that I sat through. 185 out of the 187 basically said, well, if the trust doesn't say, then here's how you interpret this issue. And I'm like, why isn't it actually in your trust? The other two things were like temporary tax breaks, and I remembered one of them. If you own a fish hatchery over these 3 years and you have it in your trust, the trust has to have this language. Okay. I went back after that CLE and I went through and looked. Oh yeah, all 185 were in the trust that we used. That's the difference. If you've got that solid revocable living trust, it's going to address things like the sale of property and who's authorized to do it. It's going to list who the beneficiaries are, but the trustee is very, very likely in a solid revocable living trust. They're going to have sole authority to sell assets. And that's exactly what you want. So now, if it's in an estate in North Carolina, this means that the title vests in the beneficiaries immediately. So, again, here's the two things. If the person does not have any will, all right, from the point they die, those heirs at law, the next of kin, they own title to that house. That's it. If they have a will, well, then title vests in those beneficiaries when the will gets filed. And that should be it. Legally, those beneficiaries should just be able to go off and sell it, not have to deal with the executor. But look, the reality is a lot different, especially when a mortgage company is now involved. And a major asset like a house, you always want to make sure that title is completely clear and it's going to be totally passed to you if you're going to spend all that money, or the mortgage company's going to spend that money and you're paying the mortgage company back. So there are hoops that end up having to get jumped through. So even in a state like North Carolina, where that stuff ends up being title transferred immediately, there's an awful lot more. Now, what happens if you've got all of those upgrades and painting and whatnot? Well, if the title's already vested in the beneficiaries, they're the ones who have to kind of come up with the money for the new carpeting, the paint job, the new appliances, and all that other stuff. And then they'll get paid back on the back end. Well, what happens if you've got one, even just 3 kids? One of them, hey, let's go top dollar. I've got the money. Let's go ahead and put this in. The other one's, well, I don't have that kind of money. I don't know if I want to do it. And you got the third person, well, I don't think we need to go for top dollar at all. I think we should just sell it as is. And so I don't have to put out any money. And now suddenly there's all these disagreements. You don't end up with that with the trust. Now, here's with the revocable living trust. It's a solid revocable living trust. The trustee can use the trust funds to pay for the paint job, the carpeting, the repairs, the new appliances, and get everything ready for sale. And then when it's sold, okay, the net money is now going into the trust and it gets distributed to the beneficiaries. And who has to sign? Just the trustee. So if they follow the advice that we typically give, don't do this co-trustee thing. If it's only one trustee, then it's only one person who has to sign all of that paperwork, approve all of those expenses, negotiate the price. It's so much simpler on the trustee as well as the family. So again, you got that solid revocable living trust. The house is owned by the trust. No issues there, no problem. It just happens a lot more smoothly. So this is something to really keep in mind when you're trying to choose, well, should I do a will versus a trust? When you're using a solid revocable living trust, the whole settlement process becomes a lot easier, particularly with complicated things like the sale of real estate. So if you like that information, if you want to learn more, then please check out the free information at freetrustcourse.com. Again, that's freetrustcourse.com. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.